concern, there must be a reason why admitting him, unquote. Counsel submitted that the applicant had not complied with the process in respect of a presidential election and that his issues were Mr. Alwochir, for his part, maintained that the petitions in hand were a requisite foundation for constitutional deliberations of great public interest, which he ought to be allowed to canvass under the umbrella of those petitions. It is clear that the applicant believes his joinder intent to be squarely supported by both the libertarian design of the Constitution of Kenya 2010 and specifically by Rule 17 of the Supreme Court Presidential Election Petition Rules 2013, which stipulates, quote, any person who was entitled to be a petitioner in the petition may apply and be joined as a co-petitioner at any time before the conclusion of the hearing of the petition, unquote. The applicant, in his submissions, did not specifically address the question of his entitlement to be joined as a petitioner in respect of the presidential election, but devoted his attention to important issues of constitutional principle, which he was seeking to have adequately ventilated. In this respect, the applicant's course appeared more distinct by its academic element than by the object of securing the righting of an electoral wrong. It is not surprising in these circumstances that the parties who had in the first place moved the court perceived the instant application as a sheer encumbrance upon the setting of their courses towards expeditious disposal. Settlement of disputes of a practical nature is a primary purpose for which the judicial establishment was conceived and must be regarded as a real justification for any proceedings that may be lodged. Perceived against such a context of judicial engagement, the applicant's course herein, in our view, has an improbable ring, just as learned counsel have urged. And necessarily, all counsel will not welcome the applicant by way of joinder as he seeks. This court finds no practicality or sincerity in the applicant's claim, and so cannot allow it. The application, consequently, is disallowed. There will be no order as to costs. Those are the orders of the court.
The next application is the Katiba Institute application. Ms. Sarengeru, you asked for more time. Can you start us off?
Thank you, Honorable Chief Justice. I did indicate yesterday that we would go digging for information pertaining to this entity, Katiba Institute, which has applied to be enjoined as amicus. We have indeed mined some information, and that information does indicate that Katiba Institute would not qualify as amicus for a number of reasons. I have come across certain documents, my lords, and due to shortage of time, I couldn't formally place them on record, say by way of an affidavit. But I do have copies that, with your information, I could pass on to your lordships and to my learned colleagues. Yes, yeah. The long and short of it, my lords, if you look at that set of documents, it's not very lengthy. It is 16 pages. Give that a copy. And the core of our submissions, my lord, is that the affiliation of Katiba Institute with AFRICOG, which is an NGO which is behind petition number 1, makes us, number 4, sorry, makes us extremely uncomfortable with the involvement of Katiba Institute. If you look at the bundle that I have given you, page 1 is an extract from that petition number 4, the humble petition of Gladwell, Wathoni Otieno, and somebody else. Paragraph 2, she states quite plainly that she is the executive director of African Center for Open Governance, AFRICOG, a non-government organization registered in Kenya, and so on and so forth. Now, both AFRICOG and Katiba Institute are members of an umbrella body known as KPTJ. And if you look, just going through that bundle, page 2, you can see the board of directors of AFRICOG. There is the petitioner number 1, Gladwell Otieno, appearing there. And at page 4, there is an exposition as to who KPTJ is. They say they're a coalition of over 30 Kenyan and East African legal, human rights, and governance organizations, together with ordinary Kenyans and Friends of Kenya, convened in the immediate aftermath of 2007 presidential election debacle. And they go on to state what their objectives are, and they also list the members of that umbrella body KPTJ. Of critical importance, my lords, is number 1, AFRICOG. Over the page, item number 21 is ICJ. And at item 27 is Katiba Institute. So you can see that these are coalition partners. They pursue common objectives under the umbrella of KPTJ, and therefore they would share certain positions that we would consider prejudicial to certain parties in these proceedings. And what's important, my lord, if you look at pages 6 and 7, is that KPTJ and the NGOs under its umbrella are not passive observers as far as the political goings on, as far as the electoral processes are concerned. Page 6 is a conference at 10:30 a.m. Sunday, Hilton, downtown Nairobi. The Kenyans for Peace with Truth and Justice, KPTJ, will hold a press conference to discuss members' observations of the primary voting process and share with the public their concerns with the extent of malpractice and lack of enforcement of election-related laws by the institutions charged with enforcing political party discipline and the conduct of elections. So there you go, umbrella body taking a very firm position. They are passing judgment. They're saying IBC cannot deliver, and so on and so forth. They are not passive. This is confirmed at page 8, where they say, last paragraph, KPTJ members are tested veterans of the last election crisis and have stayed continuously engaged in the process since. So this is going to be an important discussion that in my mind exhibits the weight of outside official delegates like the recent AU mission in terms of understanding the immediate situation on the ground in Kenya. So they're fronting themselves as authorities and veterans who can comment authoritatively even better than the external observers. Now, in the application and even in some of the documents attached here, the key people in Katiba Institute have been disclosed. This is at page 9 of that bundle. You have Yash Palgai, you have Waikwa Wanyoike, and for our purposes, you have Sandra Ochola. Now, we have been able to get through the internet a number of articles published by these people, and we've given you a very small sampling of each of these people and the articles they have published. And if you look at page 10, for instance, you have an article by Yash Palgai, and the heading is, Kibaki has abused his office over ICC trials. The relevant part is to be found at page 11, where he says, at the top of the page, he, Kibaki that is, hobnobs with the ICC accused shown in newspapers joking with them, and relies heavily on the advice of Modaura, Uhuru, and Ruto in matters where their interests are implicated. It is hard to imagine a worst case of conflict of interests. Lower down he says, in summary, Kibaki deserves to be impeached because he has, and H is a relevant part, he has consorted and conspired with ministers who are charged with crimes against humanity. So already you can see the mindset of this writer against certain parties who are adversely mentioned in a number of these petitions. The article at page 12 and 13 is authored by Mr. Waikwa Wanyoike, as you will see at the bottom of page 13. He is a director of Katiba Institute, and it is headed, Navroji is wrong, chapter 6, Buzz, Ruto, and Uhuru. Relevant part is at page 13, where he says, my view is that chapter 6 is potent enough as far as fair legal tool to bar any prospective candidate seeking state office, be it a member of county assembly or president, from being allowed to office. So he ends at the last sentence there, he says, the various state agencies, IEBC included, have a constitutional obligation to ensure that persons whose character does not meet chapter 6 requirements are barred from running for state office jobs. So right from the very beginning, it is the position of Mr. Wanyoike, a director of Katiba, that the president-elect, the deputy president, should not even have been allowed to run, let alone have been declared a successful candidate. Finally, at page 14, Sandra Ochola renders herself, and she's talking about chapter on integrity taking the back seat. This was January this year, and she's talking about integrity generally. And at page 15, penultimate paragraph, she says, my greatest misgiving is that the outcome of the integrity case against the two ICC suspects, Mr. William Ruto and Mr. Uhuru Kenyatta, is what will provide a final word on how we go about applying chapter 6 of the Constitution. Again, expressly stated, a subjective view against two persons who are centrally involved in these petitions. The last page there, page 16, is an extract of a report that has been filed by the petitioner in number 4, a report prepared by Wachira Maina and George Kegoro. The heading is, the IEBC did not conduct a credible or fair election. Why is this important? Because George Kegoro, and this is well known, is closely associated with ICJ, which, as we saw, is one of the coalition partners under the KPTJ alliance. Net result of all this, my lords, is that Katiba Institute does not wear what you would consider to be an objective or neutral face. They come with stated agenda, with stated positions, with stated interests. And I think that consistent with the decision that you gave yesterday as far as the LSK is concerned, they should be similarly debarred from coming in as amicus. They have stated that they have previously been admitted as amicus in other proceedings. They may well have been deserving in the particular context of those cases, but for this particular case, the circumstances clearly indicate that they would not qualify. It is our humble prayer, therefore, that you disallow the application to come in as amicus. Thank you.
Thank you, Mr. Regeru. Mr. Karori, you also asked for time.
Sorry. I have also consulted with my client, and my instructions, my lord, are to oppose that application. We have filed today our grounds of objection, and we have also filed a list of supporting documents in which we have set out several articles that have been published by, in particular, Professor Yash Shaigai. Yes, that's okay. My lord, first of all, for a person to be admitted as amicus curiae, it is important that not only is he demonstrably non-partisan, but it must be visible by anybody who is looking at that matter that the person is actually non-partisan. And therefore, my lord, when the applicant filed the application yesterday, one of the things that would have been expected of such a person is to give a candid disclosure of the articles that they have published, and which tends to show what kind of character the directors of Katiba Institute have. Now, you will notice that the articles that were disclosed yesterday have nothing to do with the perception that those particular directors have of the role played by the IEBC or by the second respondent, who is the chairman. Now, my lord, we've taken the liberty of photocopying a number of them, and if you look at the very first article that we have attached, it is headed, "How can Kenyans protect the integrity of the electoral process?" Now, my lord, if you look at the second paragraph there, it says, "Despite a very progressive constitution, our electoral system still lags behind in operationalizing and enforcing the standards of the constitution requires." And this is what is important. There are many reasons for this, including an aloof and nearly contemptuous attitude for electoral integrity adopted by agencies such as the Independent Electoral and Boundaries Commission and the Ethics and Anti-Corruption Commission, which are ironically are constitutionally mandated to enforce the standard of integrity in electoral processes. That is somebody who has already taken a view as regards one of the parties to these proceedings. And such a person, my lords, cannot be said to be non-partisan. My lord, if you then look at the second, there is the issue, the second article is IEBC asking for too much in terms of the budget that it's asking for. And Professor Guy accuses the Independent Electoral Boundaries Commission of asking for too much for you to carry the next general election. Then, my lord, I will skip the article headed "How Commissions Can Be Effective" and go to the very next article, which is "Interim Electoral Team Lobbies MPs to Retain Posts." And if you look at the second page of that article, you will find, my lord, paragraph 3. It says, "But a letter believed to have been authored by officials of the IEC Secretariat questioned the credibility of Mr. Isaac Hassan, and a section of the commissioners said to be eyeing the position in IEBC. The letter accuses Mr. Isaac of having undermined the former Constitution of Kenya Review Commission chairman, Professor Yosh Pal Guy, when he served as a commissioner. It points to an incident when Mr. Isaac and other anti-Guy commissioners visited former President Moi to discuss ways and so on." My lord, the point that comes out of this is that there is a personal issue between Professor Yash Pal Guy and Isaac Hassan. And my lord, a person who comes in with a position that can be said to be informed by a personal grudge between him and one of the parties to these proceedings cannot be said to be non-partisan. And then, my lord, finally, in the articles, there is the last, which is a petition is a supreme test for reformed judiciary, again written by Professor Yash Pal Guy. And the second page of that article, the professor then says, "The Kriegler Commission made a number of recommendations to ensure that these defects and inefficiencies would be cured and Kenya would never have to face a similar disaster." Then the next paragraph, "Now there is a sense of deja vu, and many Kenyans and foreigners are asking whether the Ahmed Isaac Commission," you notice again it goes to the person. He starts by mentioning the name of the chairman, "has repeated the debacle and worse of the Kivuitu Commission. The question now is whether it has failed to safeguard the Constitution, particularly the electoral process." Now, my lord, the question of the manner in which the electoral process was handled is an issue for determination before this court. Now, Professor Guy has clearly taken a position regarding what his view is of the manner in which the electoral process was handled. Now, my lord, that cannot be a party that is said to be neutral, non-partisan. That is a person who should have filed his own complaint. And so, my lord, for a person like that to come and apply to be an amicus curiae without disclosing the content of his views regarding the parties that are already in the proceedings is wrong. There was a duty on him to make a frank and candid disclosure of the kind of attitude or views that he holds regarding the parties that are already appearing before you. And once it emerged that he holds views that are against any of the parties, then immediately the court would have refused to allow him to come in as amicus. So the fact of failure to disclose the extent to which they have been involved in making comments about the character and the conduct of the elections by itself disqualifies them from being admitted as amicus curiae. Now, my lords, apart from what we've said regarding the articles, if you look at Article 22, which then talks about the right of an institution or an individual to be admitted as amicus curiae, it is very clear that it must be on the basis of a special knowledge of some law. There must be something special that you're bringing into the proceedings. Now, all that Katiba has said is that they are knowledgeable on the provisions of the Constitution. My Lord, everyone that is appearing before you today, including the Honorable, the Attorney General, and all the lawyers that are sitting before you, do nothing else but deal with questions about the interpretation of the Constitution. There is nothing outside the reading of the Constitution and the interpretation of the Constitution that has been put before you that is unique insofar as Katiba is concerned. And so, my Lord, what is this special knowledge? What is the special character that will be brought by the involvement of Katiba in these proceedings? Because from the ruling that you delivered yesterday, already the Attorney General is being admitted because of that particular reason. So why would you be admitting somebody else who says they have read the Constitution and they understand it and therefore they want to be admitted so that they can come and make submissions in connection with the Constitution? If that was allowed, my Lord, that would mean that practically any lawyer that has read the Constitution would come and make a similar application, and there would be no end to it. So, my Lord, in the absence of peculiar reasons or special circumstances or special knowledge, there is absolutely no basis on which Katiba would be admitted as amicus curiae in these proceedings. And for those reasons, my Lord, we urge the court to reject the application for admission as amicus curiae and allow the application to proceed. And my Lord, before I sit, may I just say this. From the proceedings yesterday, it is clear that the court has very little time to deal with this matter. In fact, we are not able to agree on distribution of the available time. Now, somebody else is saying that he needs to be allowed to make not only written submissions, but also wants to come and make oral submissions. Quite clearly, my Lord, at this stage, there's absolutely no time to be allowed for somebody to come in the absence of special reasons, to come and make those submissions. And so we urge the court to reject that application. That's all.
Just on one point.
Yes, my Lord.
Just as a matter of information, I think the uniqueness of Katiba Institute is something you should dig up.
Yes.
Or talk to your colleagues about it.
No, my Lord, what I was saying is that they haven't disclosed in their application and in the affidavit they have filed, they have not disclosed any special circumstances that entitles them to come in as amicus curiae. Because what I have said is that they have been admitted as amicus curiae in 2 or 3 other cases. I've read about
and that's
Katiba.
the point.
Yeah, and that is the point that I'm making.
Yes.
So if there was
no, I'm saying that's the point, that
yes.
they have been admitted. So it's that's. But let's not argue it. I thought you probably not read their work.
Yes.
But if you have, that's fine.
I have, my Lord.
Yes. Okay. Thank you, Mr. Karori. Mr. Ngatia, how are you this morning?
Fine.
Yeah.
I'll try this technology today.
Yes, just try it. You're close to it.
My Lords, as I understand this branch of the law, in the scheme of things, when considering whether to allow somebody to be amicus, one of the first considerations is the impartiality of that person. Mm-hmm. Number 2, the scholarship that that person is to bring to the court. But the scholarship is not unique to a person. I think, therefore, in the scheme of things, impartiality becomes the most important. My Lords, within the limited time that was available to us, we were able to find an article written by Katiba Institute. It's a very important article, my Lords. It's an article that was done late last year. It's on the, the heading is Report on the Implications of a Kenyatta / Ruto Presidency in Kenya. Implications of that presidency in Kenya. If my Lords want to turn to page 2 of that report, right on top, it reads, this report is prepared jointly by the Kenyan section of International Commission of Jurists, ICJ Kenya, Katiba Institute, and the Kenya Human Rights Commission. So 3 organizations are co-joined in writing this article. In the fullness of time, my lords, I will request you to read it, but for purposes of my brief submissions, I request you to turn to page 18. Page 18. Page 18, the last but one paragraph, the one starting for the reasons. Page 18, last but one. For the reasons canvassed in this report, presidency by persons facing prosecution before the ICC would be inherently problematic. Even if the courts clear them to run for ICE, and even though they undoubtedly are popular, very prophetic, they are popular, a presidency by either Kenyatta or Ruto is likely to hobble Kenya, as it would be impossible to conduct national affairs while the president is away on trial. In the event of non-cooperation in the trial, another chapter of difficulties will be opened for the country. While Kenyans have a right, or the right to elect whoever they want, and while it would be necessary to respect democratic choices, this would not take away these well-founded concerns. In a sentence, my lords, Katiba Institute, in this article and many other articles, show one thing. They have a very deep-seated resentment towards the third and fourth respondents. They went on a crusade to tell Kenyans why these two gentlemen should never see corridors of political power. This article, my lord, featured in the daily newspapers, and there are numerous such articles, all to one agenda, that these are not people worthy of being considered for any political office. My lords, we are ready to get the engagement, a front-on engagement from the petitioners. But another engagement from somebody coming as amicus curiae would be very unfair. Let us limit the engagement to our political opponents, and my lords will find that actually quite a number of comments here are the same comments that the third and fourth respondents' political opponents routinely talk about. ICC, integrity issues, and all those things. My lords, by this article and many of like nature, Katiba cannot be considered as a friend of the court. Katiba is an opponent to the third and fourth respondents. Regrettably, they did not file a petition, which we could have engaged them on, and it's on that basis, my lords, that I would request you not to allow them. Before I conclude, a few comments about this motion. My lords may have noticed that the motion is supported by an affidavit written by Waikwa Wanyoike. Waikwa Wanyoike is one of the directors. He has done a very brief affidavit. Nowhere in the affidavit has he said that Katiba Institute does not have an axe to grind with some of the parties here. For one reason, because they do have not just an axe, but a huge axe to grind with my client, the third respondent, and by extension, the fourth respondent. The other thing is, which was alluded to and which I'll touch very briefly, is the want of disclosure or the lack of disclosure about certain passionate positions they hold. They failed to disclose that, again, because they thought that this would be an application that would be dealt with routinely or summarily. My lords, every litigant has a duty to the court, and that duty goes beyond a partisan position. They had a duty to disclose that they have written very nasty articles about the third and fourth respondents. They failed to do so because they intended to gain an advantage an advantage by failure to disclose. All those are factors, my lords, which, in the scheme of things, should disentitle the adjoinder as amicus in this petition. That is all, my lords.
There is absolutely no value they will add to these proceedings. My lords, I share the position taken by my learned senior, Mr. Ngatia, being that it is evident from everything and every opportunity that has been availed to the Katiba Institute, including Professor Yash, that at every opportunity he has had, he has never missed an occasion to mention the fourth and the third respondent, and to say they have no integrity. And my lord, it is our submission that their request to participate in these proceedings is a request to be afforded another window to try to demonstrate why they should not have a chance, regardless of the faith the Kenyans have in those two people. And my lord, we pray that having cast their thoughts and having expressed their position, they should not be afforded another window to try to improve their case as against the third and the fourth respondents. It is our submission, my lords, that the attitude against the fourth respondent and the third respondent is not only vicious, but it is emotional. My lords will see that the use of the words obsession, and according to them, any moment anybody is not only vicious, but it is emotional. My lords will see that the use of the words obsession, and according to them, any moment anybody associates with the two, either as friends or consults them as an advisor or otherwise, is already conducting himself with an obsession. An issue to grind, that they have an attitude against the fourth and the fifth, the third and the fourth respondents. You should not allow them to participate as amicus, and we rely on the test you already established in the case of Law Society, in which you said the criteria of bias is a consideration that should disentitle a party from participating as an amicus. For all those reasons, my lord, we pray that the criteria of bias is a consideration that should disentitle a party from participating as an amicus. For all those reasons, my lord, we pray that you disallow the application. Thank you.
If I may, we have one authority that we would want to share with the court first, I guess the respondents and the petitioners. So I'll just have it passed. That's the court copy. And we before a response, we wish to. No, I only heard those four people who said that.
Pardon, my lord? Yes. Yes, but my lord, yeah. On instructions from my learned senior here, we are about to look at this matter, and we have a position that we wanted to put to the court. Yeah. Maybe my lord, maybe can then state our position now, so that then I can submit on it, because. Have you changed that position? Because you said this to be Sorry.
Strict limits or limitation on the exercise of that status.
That's right.
Yeah.
Because when Professor Yashpal Gai submitted to the court, I assumed that he would limit himself entirely to his professorial function of talking about the Constitution per se, and not enter into any other fractious issues. Overnight, we have got all this new information about the articles he's written, and particularly about the attack he has launched upon the IEBC.
So that's taken care of. We can take that.
Now my learned colleagues have addressed you on that.
Yes.
And we would like that position to be taken.
Your position.
As our position.
Okay, that's fine. We will record that. Thanks, Mr. Nyaoga. So, yes, Mr. Waikwa?
Your Honors, I will ask Professor Guy to first address the court on some of the issues that have come up, and if there will be any additional issues, then I could request the leave of the court to be able to canvass those. Thank you.
If you can actually address us, I think what has come out very, very clearly and has been articulated is the issue of bias, partisanship. You have had counsel, if you could respond to that.
I could do that.
Yes.
Those are the directions of the court. The first response I want to argue relates to KPTJ, our membership in KPTJ that was brought up by Mr. Regero. One thing I should say is that KPTJ stands for Kenyans for Peace, Truth and Justice. It's a loose membership organization, of many organizations that work in the civil society sector. We are members of that coalition. There are so many members, as the documents show, very distinguished civil societies, organizations, including, for example, Kituo cha Sheria. The fact that we are members, or we are members of a loose coalition within the civil society organization does not in any way indicate our lack of independence or our lack of impartiality, because the connection I got from Mr. Regero is that because AFRICOG is there, then we are also, or we share the same opinion as AFRICOG. On some issues, yes, we may share that opinion, but on some other issues, we may not. So I do not think that should be a ground to disqualify the institute. The second thing relates to the issues that have been raised mostly by the third and the fourth respondents in relation to integrity and ICC. The petitions, I did not see issues of integrity being issues to be determined by this court. I never saw anything to do with ICC being an issue to be determined by this court. All that has to be determined is the validity or lack thereof of the presidential election. So I don't think that those issues are relevant, and our opinions on those issues, I don't think matter for purposes of what we want to engage in. And we have particularized in our application what issues we want to engage in. Honorable Justices, I have to say that Katiba Institute does a lot of opinions in the press and everywhere, as has been shown by some of the councils here. We have a lot of opinions, and we have a lot of opinions about a lot of people, not just the third and fourth respondents. And to the extent that this court is sitting with a mandate to interpret the Constitution, we are protected, or we should be protected, to be able to express our opinions. The opinions we've expressed are not directly related to the issues before this court. And so to that extent, whatever opinions have been filed with the court, those opinions are, in our view, irrelevant for purposes of our application. But more importantly, it cannot be said that any organization that intends at one point or another to be an amicus should never have shown to have expressed an opinion on anything or on anyone. want to address the issue of LSK. As far as I understand, the court's ruling on LSK related to the fact that some of the evidence being used by the court, or that might be used by the court, actually came from an issue of LSK. We don't have a similar situation here. None of our information, other than the submissions that we propose to be issues, other than the opposition that we get. On the issue of impartiality, and now I want to go to the test. We have provided the court with a copy of the case. And I want to refer the court to the last page, paragraph 11. And the question here for the court to come in is, what impartiality are we talking about? It's not impartiality on all global issues, on anything that a party or an applicant may have done. It is impartiality relating to the law that applies to the specific petition. And if you look, the court in Hong Kong said, I had always understood that the role of amicus curiae was to help the court by expounding the law impartially, and I want the court to underline that. All if one of the parties were represented by advancing the legal arguments on his behalf. And then the court continues, doubtless therefore the amicus submission to the court will impartially deploy all relevant points irrespective of whether such points assist one side or the other. So in my submission, the impartiality here is not whether an organization or the intended amicus has expressed opinion on other matters. It's a question whether they are able to be impartial in relation to the proceedings before the court. And we have shown that in the last, or the various times that we've been admitted as amicus by this court. We've actually, in the election date case, which we also served as an amicus, we disagreed in our position with other, or most of the civil society organizations, and held one position that was very different, even though we were still members of KPTJ, and some of those were members of the KPTJ. So I think it's up to the court to apply the proper test and not to be swayed by irrelevant considerations that those who have opposed this application has made. Finally, I think it's important that this court takes a cautious approach in determining the qualification of amicus. If, in fact, this court casts a net too wide, as those who have opposed the application would want, it means that nobody, in my view, will ever qualify as an amicus, because anybody who has in their lifetime had an opinion, then they would not be able to qualify. I will leave it at that, and maybe I'll just ask Professor Guy whether he has any comment with leave of the court.
That is for the court. It is for the court to ask Professor Guy to do exactly what you are purporting to do. Thank you.
Professor Yash Guy, do you have a comment?
Yes, thank you, Chief Justice. I don't have a great deal to add to my colleagues. I'd like to emphasize his last point, that if the tests are as the respondents argue, then it would be very difficult for a large number of institutions to participate in legal proceedings. The Constitution places a very heavy emphasis on participation, public participation, in public affairs. The chapter on the judiciary also refers to participation of people in the judicial process. And we have, ever since the enactment of the Constitution, tried to promote the participation of people by our writings, by workshops, and by our own appearances in the appropriate cases. I think the role of the amicus is to assist the court and the litigating parties about the law, the different interpretations, and this is what we have done in the cases that my colleague mentioned when we have been amicus. I think to have a restrictive test as to who qualifies as amicus, particularly in the area of public law, which by its nature is political, is to bar a very large number of Kenyans from their right to participate in legal proceedings. I haven't had the only document I received was Mr. Karuri's, and I would like to say a few words about his conclusions and the attachments that he has distributed. The very first document, which is dealing with how Kenyans can protect the integrity of the process, the electoral process, was written because we felt that maybe not enough civic education had been undertaken by the Commission. We felt that this was an extremely important election in which it was necessary that people participate with knowledge of the process. It sets out in some detail the different aspects of the electoral process and how people can participate in it, as well as help the Commission in the supervision of the process to make sure that the constitutional requirements are met. I see nothing objectionable in that. Indeed, it is very much in line with the mandate of the Institute to inform people about the Constitution and to facilitate their participation. The second one is a report from the Nation where I was interviewed after I gave a lecture at the Danish Embassy on the 50th anniversary of the Danish International Development Agency. I don't think that the correspondent was present there. I take objection to some statements attributed to me. I'll give you one example. He says that I have argued that commissions have proved expensive for the taxpayers because some members are appointed on permanent terms. I had said during my presentation, full-time members, because it is my view that, and the Constitution does provide as well, that many members of commissions could be part-time, and a lot of the work would be done by the Secretariat. This was my own experience in the CKRC, and I believe that is also the view of the present chair of the Electoral Commission. There are other statements there which I have not said. The last line, he said that even though reforms were being carried out in the judiciary, the vetting of judges was not satisfactory. This was a statement even before, or just as the process was starting, and I have not taken positions on this issue. There is always a hazard, as we all know, in the press reporting by the media, and this, I'm afraid, is another instance of misreporting. I now turn to the article, How Commissions Can Be Effective, which was written in the Star. Page 2 of this document is missing from the dossier I was given. But let me deal with the question which has been raised, that there is animosity between Mr. Isaac and myself. I want to tell the court, these are personal matters, but they have been raised by the respondents, that Isaac and I are very close friends. We respect each other. During the last 2 years, we have collaborated with the Commission at the request of Mr. Isaac. We have assisted the Commission in developing ideas and provisions for the effective representation of women. At his request, we invited a leading Norwegian expert to come to this country, and we had a meeting in Nakuru and a meeting in Nairobi, which Mr. Isaac told me was one of the most fruitful meetings that the Commission has had. The purpose of this article that is quoted was actually to defend Mr. Isaac. There was an article by somebody called Kikunya Bose, which heavily criticized Mr. Isaac. I felt the criticism was unfair, and I therefore responded to that criticism, and this is the article that is now attached here. I say that I did have differences with him, and some of these have been recounted by Mr. Patrick Lumumba in his book, The Postponed Promise. Then I go on to say, although Isaac was considered to belong to a group that opposed me, I was always able to have perfectly sensible and amiable discussions with him, including on Islamic law. Unlike some other commissioners opposed to me, or just lazy, he attended commission and committee meetings regularly, making valuable contribution. The youngest commissioner, he matured considerably as our work progressed. Towards the end, as he saw through the machinations of some commissioners deemed or described as his co-conspirators, he committed himself wholeheartedly to the completion of the draft constitution. As far as outsiders like me can tell, he has now distinguished himself in the conduct of the referendum and recent by-elections. And that's all views on how the independent commissions which have been established under the Constitution. The rest of the paper is my views on how the independent commissions which have been established under the Constitution could be more effective. So you can see there that I have defended Mr. Isaac. I've had several conversations with him over the last 2 years when he has sought my advice on one or other legal or political issues. Indeed, only recently he called me on some important matter and wanted my opinion. I would rather not give the topic of the issue that we discussed, but I want to put at rest that there is any animosity between him and me, and that we have sought to intervene in these proceedings out of any vindictiveness. I could go through other attachments too to show how they don't really indicate that we are, as Katiba or I as an individual, have come to this court to damage the reputation of the Commission or to cast aspersions on Mr. Isaac. The letter, that attachment, which is the attachment, it's not paginated, so it's the interim electoral team lobbies MPs. deals with the letter which was written by several people to oppose the reappointment of Mr. Isaac to the Electoral Commission. In the letter, they cite his attempt to undermine me as commissioner, as chair of the CKRC. I have nothing to do with this. It's the first time I have seen this report. I must have missed the newspaper, so I have no responsibility for what is in this report.
Professor Ashgai, how long will you be?
Well, I will take maybe just one last point from the mixed reactions after IEBC clears Uhuru and Ruto. It accuses me for a statement that I made in the context of whether the decision by the IEBC is final or whether it could be queried. I say here the court's ruling in the context which was being discussed then, that there could be an appeal or approach to the courts about the eligibility of these two candidates. And I am quoted here as saying, if it went to the court's rulings will largely be based on what the Constitution says. I am now being castigated by the respondents for upholding the independence and the proper role of the judiciary. I have more points to say, but I realize that we're all short of time, and I'm grateful to you for letting me have this opportunity to explain these documents. Thank you, sir.
Thank you, Professor Ashgai.
Yes, right.
We'll give our ruling on this issue at 3 p.m. I think the next issue is Ms. Kalonzo's issue, the notice to produce. So, but they all know about the notice. So let's have the responses now from the council. Is that all right?
My Lord, after I make my application.
You made your application yesterday.
No, I didn't, my Lord.
It's stated in your notice to produce.
No, my Lord.
Is there anything else you want to add?
Yes, my Lord.
Yeah,
I would like to refer to the petition, which sets a background and the context of the notice to produce, and the regulations regarding the registration of voters, the Constitution, and the Elections Act.
Okay, go on.
Thank you, my Lord.
Yeah.
My Lord, yesterday, this court ordered, on its own motion, the scrutiny of forms number 34 and 36. Part of the scrutiny that this court ordered is the registered number of voters in those forms. My Lord, this court requested the second respondent in the first petition to provide it with the electronic copy of the principal register. My Lord, it is my humble submission that this court has original, unlimited, and exclusive mandate to determine presidential election petitions. You have every material used in the conduct of the presidential elections. My Lords, you moved suo motu and ordered scrutiny. That is the exercise of your jurisdiction. My Lords, the rules of the court cannot fetter your powers to order scrutiny of any election material. Article 86 of the Constitution provides that whatever voting method is used, that system must be verifiable. There are many standards, but one of them is verifiable. My Lord, the Black's Law Dictionary definition of verifiable means answerable, truth. IEBC has provided this court with original Form 36 manual, original Form 34's manual. The question is, the electronic register that they have provided you with, is that the register that was used during the election? And can that register verify the number of registered voters indicated in the manual forms they have provided you with? My Lord, the answer is no, a resounding no. Rule 15.2 of the Supreme Court Presidential Petitions rules requires that the second respondent in the first petition supplies this court with Form 36 2 days after it is served with the petition. My Lords, the Independent Electoral Boundaries Commission, when it served us with the response in petition number 5, gave us soft copies of Form 36, the provisional register in soft copy, the principal register in electronic copy, and the database for the results transmission system. We did not request for any of these forms. They acted under their obligation to be accountable and transparent. The question is this, my Lord. If this electronic register of voters was not used, and they used the manual register, why hasn't the IEBC provided that manual register? My Lord, if they object to this notice to produce, other than the question of form, this court should ask itself why. Is there something that they are trying to hide? My Lord, the first prayer in petition number 4 touches on the principal register of voters. It is my humble submission that that register becomes a material, relevant, and pertinent issue before this court. It is my humble submission that on the material of IEBC alone, the electronic register cannot be used to verify the registered number of voters in Form 34 and in Form 36. Why do I say so? The affidavit of the returning officer to the presidential elections, the first respondent in petition number 1, states that they used the manual register. The electronic voter identification system failed. And where it did, they resorted to the manual register. They have attached, my lords, the IEBC has attached a report by ELOG. This is an association that observed the elections. They are bound by that report. My lords, that report states in 8% of the polling stations, 8%, 2,500 plus, the EVID, the electronic voter identification system, was either never provided or it malfunctioned. That is not denied in the evidence of IEBC. ELOG states in its report 55.1% of the polling stations, 21,000 plus of the polling stations. By 8:30 p.m., that system was malfunctioning, but they resorted to the manual register. How do you verify the truth of who the registered voters are? My lords, it is my humble submission, and this is borne by the evidence in the petition, that what we are asking this court to do is not an exercise in academic pursuit. There is evidence before this court, and evidence that is supported by the affidavits that have been filed on behalf of a third respondent, that the numbers in the principal register, the number of registered voters in the principal register differ significantly from the number appearing in Form 36 in no less than 180 constituencies. (60% of a polling stations. My lords, when you are considering this application, I'll invite you to look at the replying affidavit by the returning officer, chairman of the IEBC, dated 22nd of March 2013, at paragraph 18, page 5 of his replying affidavit. He states that there were 31,318 voters who did not have biometrics, and therefore they compiled a special register for them. My lords, we have attached at page 558 of our petition. I will invite you to look at it when you're considering the notice to produce. According to the IEBC website, on the 2nd of March 2013, 2 weeks after the principal register had been gazetted, they published a list of voters without biometrics per county, and the total number, according to their website, my lords, the total is at page 559, is 36,236. How do you verify the truth or falsity of that list if you don't have the register that was used, the marked register that was used at the respective polling stations? This court is conducting its own scrutiny as we speak. At the conclusion of that scrutiny, it is our humble submission that you will find that there's a discrepancy between Form 36 and the declaration of the presidential elections. The discrepancy is in the number of registered voters. The registered number of voters for over 180 constituencies in Form 36 differ significantly with that in the declaration published on 9th of March 2013, and the difference is over 70,000 registered voters. The question is, my lord, if you find that difference, and I dare say you will, what do you do in the absence of the manual register? How do you settle the question of what register was distributed to the polling station, what register was used? It is my humble submission that the register of voters goes to the root of the general elections. It goes to the root of the presidential elections. My lords, if this court feels that you're constrained by time, it is my humble submission that you can scrutinize the declaration of the summary that was published in the newspapers and Form 36. To scrutinize the number of registered voters with the electronic register will be an injustice, because that is not the primary document. My Lords, you will be addressed about the question of I am addressing this court on the basis of a notice to produce. My Lords, it is my humble submission that the burden of proof that there were irregularities and breach of the law and the Constitution rests on the petitioners. That burden of proof cannot be discharged if one party who has custody of the primary election material is monopolizing that information. In fact, I dare say that that primary election material, the marked register, should not be in the custody of a party who is a respondent in an election petition. That material should be in the custody of the court, as is the practice in the High Court in parliamentary petitions which are of a less significance than the petition before you. My Lords, it is my humble submission that those registers, those marked registers, will never be used again. They are of no value to the Independent Electoral Boundaries Commission. They will never be used again. But they are of immense value to the petitioners case, and to this court.
Can you just expound on that one?
My Lords, the register of voters that was distributed to the 33,000 polling stations, the manual register that was used has already been marked to show the persons who appeared at the polling stations to vote. If there should be, if this court so determines, another presidential election or another parliamentary election, the IEBC will have to print another copy of that register. The marked registers in their possession cannot be reused. They are of no value to them, my Lords. And the fact that we are before you this morning and that you have the conduct of this petition, that material should be in the custody of the court. And the IEBC should tell this court why they feel that they should keep this material or why they feel that this material should not be produced, irrespective.
One
yes.
other question. What would be the source of that second printing? Where would they register from?
My Lords, under Section 3 and Section 4 of the Elections Act, there is a principal register. 3, yes. There is a principal register. Copies of that principal register in manual and electronic form are required to be distributed to every polling station, poll register, to every county as a county register, to every constituency as a constituency register. The principal register that you have in electronic form was not at the polling station. That is my point. And it was not used at the polling station. The entry for registered number of voters was derived from the marked register, the primary document. My Lords, if you allow me, because it is part of our evidence which we'll be presenting tomorrow, in Kieni constituency, polling station number 083 is Charity Primary School. The principal register of voters indicates there's one voter, one. That is what is available on the website of IEBC. We have checked the list of voters without biometrics. That polling station doesn't appear. According to Form 34 that has been supplied by the IEBC, 321 people voted. The presiding officer does not indicate who the number of registered voters in that polling station are. The question, my lords, I pose is that once the report discloses that 321 people voted and the principal register shows one, and the presiding officer doesn't indicate how many registered voters were at that polling station, how will this court verify what register was used at that polling station? The same for Machakos Town constituency. According to the list of voters without biometrics at page 558, derived from the IEBC website, there were only 125 people in Machakos County, the whole county, who appeared in the list of voters without biometrics. Form 36 on Machakos Town constituency, the difference between the number of registered voters in Form 36 and the declaration of results by the IEBC is 3,182. One constituency in a county which has only 125 the biometrics list. My question again is, once you receive your report.
Excuse me, Council.
Yes, my lord.
Are those not issues
for
obliged. Tomorrow?
I'm most obliged.
Yes. So I don't think they are necessary at this stage when you are pressing for your notice to produce. So you can reserve your argument for tomorrow.
Thank you, my lord. I'm most obliged.
Yes, and move fast.
Yes.
I would also like to say something.
Yes,
Ms. Kilonzo. I think you are taking advantage, with due respect, of the liberty we gave you, and at our own instance, that we made suggestions, that we have an idea as to the intention of the notice to produce, the nature of the documents you want, and in the event that the other party agrees to grant or accepts to produce the documents, or if we compel IBC to produce, what impact it will have on management of the case. The idea was not to argue the evidence before the court.
I'm most obliged, my lord, and I'm duly guided. My lord, in view of your directions, I will limit my final submissions to 2 issues. And the first one is a question of resources. My lord, I humbly submit, that the Constitution of 2010 was a byproduct of a bungled election and post-election violence. The people of Kenya promulgated that constitution in which they created not only the IEBC, but also this court to resolve disputes on presidential petitions. My lords, you would have thought that after such a murky history, there would be voter apathy. Over 12 million Kenyans stood in queue for over an average of 6 hours to vote. My lords, it is my humble submission that the right to a free and fair election cannot be measured in financial terms. The hours Kenyans spent on the queue and waiting for the results of this election, my lord.
With due respect, Ms.
Yes.
Kilonzo, I think you are getting out of bounds of the parameters we gave you. In fact, strictly speaking, a notice to produce is not an application, and we have told you twice, if not more times.
My Lord, it is my humble submission that this court, in its creativity and ingenuity, can get resources to conduct this exercise, even if it is in the constituencies whose number of registered voters are in dispute or in contention. My Lord, it is my humble submission that Article 159(2) of the Constitution states that justice shall be administered without undue regard to technicality. This court, of its own motion, can request for the production of those marked registers, the manual marked registers, and it is my humble submission that it is in the interest of justice that those marked manual registers are produced and kept in the custody of this court. That is all, my lords.
Mr. Nyamondi, do you want to go first?
My lords, good morning. Before I respond to the submissions of my learned colleague, my lords, I wish to book a place in the court's cause list. I wish to make a small application at the court's convenience, an oral application arising from the directions that were given by the court yesterday about the scrutiny. So perhaps when it is convenient to court, I, with the court's permission, will make the application.
You want to make an oral application?
Yes, an oral application.
About the ruling?
About the execution of the ruling.
It's being executed as we speak.
My lords, the court had, maybe if I can just do it briefly, the court had directed that the commission supplies to the court all the registers it used, and one of the registers that were used in the election was the register that is referred to as the Green Book. When we left court yesterday evening, we proceeded to our clients' offices and asked them to produce the Green Book to court. We were informed that the Green Book is resident in the constituencies and regional offices, and they started the process of collecting it last night. The ones that have been collected have been passed on to the registrar, and what I wanted to inform court is that they will all be delivered to court on or before tomorrow morning.
I don't recall us talking about the Green Book. It's okay, we will hear you later, because I think that's important, yeah? Can I see this? Yes.
Yes, my lord. In response to my learned colleague's submissions, as I struggled yesterday evening to understand the new meaning that was being ascribed to a notice to produce issued under Section 69 of the Evidence Act, I was reminded by the court that this is not a hearing, this is not a trial, it was just a pre-trial conference. So I shall restrain myself, and I shall not respond, my lords, to the substantive submissions that were made by counsel for the petitioner in petition number 4 about the register, about the manner in which people voted, and about proof as to who voted and how many people voted. My lords, I wish to state that counsel for the petitioner in petition number 4 seems to be making an application for scrutiny of the register. My lords, the law is clear that before scrutiny of any election materials is ordered by the court, my lord, the basis needs to be laid by the person seeking scrutiny for that request. In this regard, my lord, Regulation 93 of the Elections General Regulations is instructive. In sub-regulation 1, 2, 3, and 4 of Regulation 93, the procedure for a request such as the one being made by the petitioner is set out. My Lords, in respect of the submission made in respect of Form 36, Rule 12, Rule 15, Sub-Rule 2 of the rules of this court was amended. The time limitation for the submission of Form 36 to this court by the Commission was removed, and I believe the Commission has now complied with that rule. My Lords, the information which the petitioner seeks is dealt with in Regulation 73 of the Elections General Regulations. And my Lord, it is indeed true that they are sealed in tamper-proof envelopes at the end of the election by the presiding officer in each polling station. My Lord, whilst on my feet yesterday, I indicated to court that those tamper-proof envelopes are then for the further and better security of the envelopes, then sealed by the presiding officers in ballot boxes and presented to the returning officer. My Lords, I wish to produce the training version of the polling day diary for presiding officers prepared by the Commission and issued to all presiding officers giving that direction. It's a brief document. It's an extract of the polling day diary. And on the page marked 20 at the bottom, in paragraph 13, it says, in addition to the ballot papers sealed after counting, ensure the following packages are put in ballot boxes. Number 8, within the margin, is marked registers. So, my Lords, that is where the document, that is where the information that the petitioner seeks is. My Lords, the information is available, but it would require some time, and it would require an order of this court, as is usual, to break the seals in the ballot boxes where those registers are, remove the tamper-proof envelopes, open them as provided as provided by Regulation 93, and then have them delivered to court. According to the Commission, that would take a week to 10 days to do in respect of all the 33,400 polling stations. My Lords, the printed copies of the registers run to nearly 750,000 pages. My Lords, it would be an immense expense to have them photocopied. My Lords, if the court is minded to order that the petitioner be supplied with those copies of the register, then the Commission would avail them, of course, at the petitioner's expense. So, my Lords, I will leave the issue of the substantive issues of the register to the trial, and I will leave the matter to court with that brief response.
We have quick responses from other counsel. Mr. Braguero.
Thank you, Chief Justice. The notice to produce is really not directed at my clients, so I may not have much to say. Suffice to state that, yes, in the interests of time, we keep saying this, we need to observe it. Yesterday, this notice to produce had been given 15 minutes for all of us to submit. Ms. Kilonzo has taken double that to argue part of her substantive petition. It would have saved us dear time if we had gone straight to the point and been limited in our time. But I think there is also a need to cut to the chase here, because suo motu, your lordships and my lady directed that a scrutiny, a very comprehensive scrutiny, be carried out, and as you confirmed, my Lord Chief Justice, this exercise is going on as we speak. It seems to me that the foundation of this exercise necessarily has to be the register that formed the basis of the voting in the first place. Now, what that register is, whether it was in a green book or black book or red book or whatever it is, it does need to be settled. Because if that foundation is not laid and it is not firmly established, then you find that the resultant scrutiny is similarly on shaky ground. So for a meaningful exercise to be carried out of scrutiny, I think it would be important that these primary considerations of the completeness of the register, and I think in fairness to the court, we need to be presenting to you the totality of the registered voters who are entitled to vote. And then what might have happened subsequent thereto in terms of spoiled ballots or rejected ballots or whatever it is, may be issues of comment and so on. But what is the starting point? What was on the table against which we all went to vote on the 4th of March? That foundation needs to be laid so that the scrutiny is meaningful. To that extent, therefore, it seems to me that this notice to produce is really, in the words of my learned friend, no more than an academic pursuit, because the needs of her clients will be addressed in that scrutiny, subject, of course, to a proper establishment of that register and all the consequential steps that have to be taken in terms of how many votes were then cast, how many of those should be sidelined as rejected, how many qualified to found the basis of the declaration, and so on. Everything else you will find falls into place. Thank you.
Mr. Moraro.
Thank you. I fully support the application by my learned friend. And indeed, my position, my lords, is that she is entitled as a matter of right to the documents she is seeking. And I say so for two reasons. The first reason, my lord, is that by virtue of Article 159, 2D, which was being rubbished yesterday, this court cannot afford to rely on technicalities on matters of election petitions. And my lord, that is emphasized specifically by the provisions of the Elections Act. And under the Elections Act, my lord, at section 2, election court is defined, and election court includes this court. And the Elections Act enjoins this court in exercising its powers in an election petition to decide all matters that come before it without undue regard to technicalities, consistent with what the Constitution provides at Article 159 2D. You find that at section 80, subsection 1D. So that, my lord, there is no need, the IEBC insisting that this is merely a notice to produce, and therefore we ought not to produce a document which is necessary for the purposes of determining the issue before you. Second issue, my lord, is that the register is part of the election material. And under Regulation 2073, part of the material to be sealed and retained for future purpose is the marked register. My lord, Regulation 93, which my learned friend has referred to you, is relevant, but it doesn't help my learned friend. Regulation 93 says that every citizen is entitled on an application to court to have access to the sealed material which include marked register. But at sub-regulation 4, it says, the provision of this regulation shall not apply to documents that concern a pending election petition unless there is a court order granting such authority. So citizens are restrained from having access to this material so that the election court can make specific order in respect of this material. Mr. Manod, what you ask yourself is, if the average Kenyan citizen is entitled on an application to this material, how would a petitioner be denied the right of access to such material, my Lord? My Lord, the issue of registers is shrouded with ambiguity on all the response which the first and second respondents have made to this court, my Lord. My Lord, we are today being told about a green. We are being told about a special register. The Registration of Persons Act, the Elections Act, at section 4, 5, and 6, only envisage a principal register which shall be used for the purposes of election. What we have is we are being told that on the 18th of April, there was a publication under the Act specifying that the compilation of the principal register had been completed. But my Lord, in their response to the affidavits before this court, they have annexed copies of the special meetings they have, and in your Lordship's time, when you are going through the first and second respondents' joint replying affidavit, volume 2 at page 201, you will notice, my Lord, that as at 18th February 2013, when they were telling the public that the register had been compiled, they were still dealing with the issue of register and it was not complete. They were still dealing with the issue of register on 23rd of February. And there is a dispute as to whether the political parties, leave alone the members of the public, were ever told what is in the register. So that, my Lord, the register is a live point on both the petitions before this court. And it is necessary in order for us to agitate and argue the issues concerning what did the first respondent use for the purposes of this election, to have access to that material which the law bound them to keep and provide to the public if the public so wished. My Lord, it is therefore my humble submission that the application by my Lord friend is well grounded in law, and it would be unfortunate if the IEBC, having bungled this issue of the register, is permitted now to come and produce some books called green books to supplement what is being questioned in the last election and the subject of the petition before your lordships. That's my humble submission.
Senior counsel, yes, we know that the mother of the entire dispute is the register used during the voting exercise. Now, you heard what Mr. Nyamode said, that it will take them 7 to 10 days to produce these documents. What do we do?
My Lord, it is the choice of IEBC to agitate difficulty to avoid what is their statutory obligation. The statute requires them on an application and order of the court to produce these registers to a citizen, but in the event on a petition to produce them in any event where that is a live issue before the court. Indeed, my Lord, it would really be an unfortunate day when your constitutional obligation to determine this issue is made subject to the convenience of IEBC. My Lord.
Senior Counsel, Mr. Oraro, what about the time itself? The time, today we are concluding the pretrial conference. We are beginning the full hearing in earnest tomorrow, and we have to deliver judgment by Saturday.
My Lord, what should happen?
And you can look at the date the notice to produce was filed.
Sorry, my Lord. What I would have expected is that the registers, Form 36s, Form 34s, were necessary materials which ought to have been brought to the headquarters of IEBC to be produced if required once a petition was filed. In fact, if this was what do we call it, parliamentary elections petition, those documents would have been availed as a matter of course, including the ballot papers, my Lord. It would really be unfortunate if your Lordships put a fiat that in the case of presidential elections, the registers will not be produced unless there is a prior notice to produce them, and it will depend on the convenience of IEBC, my Lord. But my Lord, without these registers, and when they are being produced in installments, as you have been told, today you have been told something called Green Book is being produced, and it is going to be used as scrutiny. We yet don't have the registers which were being used. On evidentiary level, which register will we be using, my Lord?
I think the question my father is asking is we must conclude this matter by Saturday.
Yes.
We confirm, and I think it's not in dispute, that the marked registers for which are being asked for production are inside ballot boxes. So between now and Saturday, and since the ballot boxes are scattered all over the country, the IEBC has said they cannot do so between now and Saturday, and we are inviting your comment on the same. Given the residence of where those marked registers are currently.
My Lord, first and foremost, those marked ballot papers are not at polling station level. He says there are 33,000 polling stations. These registers, by regulation, were supposed to be sealed and handed over to returning officers. There are only 341 constituencies. And when it was the issue of delivering, when it was the issue of delivering Form 34s, which were coming from 33,000 constituencies, they were delivered in 2 days. What is the difficulty now in delivering the registers? They delivered them in 2 days, my Lord, my Lady. Further, if they fail to produce the registers they used, having presented to the public that they are going to produce, to use BVR registers, now they come with 2 other registers, then their failure to produce can only draw an adverse inference, my Lady.
Mr. Abdullahi.
Thank you. Thank you, my Lord.
On this matter, my Lord, my learned friend Karori will address the court.
All right.
My Lord, I wish first to associate myself with the comments made by my learned friend, Mr. Nyamodi, because it sets out the nature of the documents that are being requested and their location at the moment. I think what my Lady Justice Joki said is quite accurate, that once they are put in the tamper-proof packets and they are put in the ballot boxes, the only way that those documents ordinarily would be available is through a court order. And there is a reason for that, my lords. Now, you will notice that even when Senior Counsel, Mr. Oraro, was addressing the court, there is a point that he did not address. When it was necessary for certain documents to be produced, a petition was actually filed in the High Court prior to the filing of the petition that was filed here. And so even to my learned friend, Ms. Kathy, there was available to her the option of filing that petition in the High Court as required under Regulation 93 for purposes of logistics to be made to avail those documents in time. And so when they filed this application so late in the day, in the middle of the hearing of the petition, and when there is hardly time for the production of those documents within the remaining time, it is incorrect and unfair to accuse the IEBC of delaying in production of those documents. The regulations require that once the ballot boxes are sealed and are taken to the constituency offices, then they can only be unsealed with a court order. And so to require that all those boxes will be removed from their residence and brought to IEBC headquarters in the hope or in the expectation that maybe someone may make an production thereof is unreasonable, with profound respect. So the reason why the legislature...
Mr. Kamau, if I may ask a question.
Yes.
I don't know whether you or represented IBC in the application in the High Court.
Yes.
In the course of our work, I came across the application, yes. And I believe that the orders were granted, yes, that you produce and serve all the documents. And I remember seeing in the list the Green Book and so many other documents, including the registers. Were these delivered? Did you deliver? Did you comply with the order?
First of all, my Lord, and it's important that you've raised that question because I've seen a lot of references to it in the petitions, particularly the one filed in petition number 5. When the application was filed, the petition was filed in the High Court. We appeared before Justice Lenaola on the 13th of March. Now, there was no order that was ever made for the production of any document. There is no such order. What happened instead is the parties, myself and Mr. Arwa, we were required to go and discuss, and if we have no problem with production of the documents, then we should make them available. We volunteered to produce those documents, and we handed over those documents voluntarily. There was never a court order. But, my Lord, the documents...
Yes, let's follow that one up. Was there an application for production?
There was an application and there was a petition.
Yes.
Which was filed on I think it was filed on the 12th. We appeared before the court on the 13th. That application has never been argued up to today.
Okay.
The petition has never been argued up to today. In fact, we have never filed any papers in response to that petition or that application, because what the judge then directed is that it is a matter which the parties can be able to sit together and resolve. So to create the impression that we only moved as a result of a court order is erroneous. These documents were voluntarily handed over. And now, my lords, the second aspect of that is that there is a suggestion that has been made. Because Forms 34 were availed in a short time, therefore it is possible for the other documents to be availed within a relatively short time. My lords, will notice that under the regulations, Form 34s are supposed to be produced at the national tallying offices by the returning officers. That is one of the requirements. And so even as the tallying was going on, the Form 34s would be produced and availed by the returning officers. The same does not apply in respect of the sealed envelopes. Those are not supposed to be brought to the national tallying office. Only Form 34s. And my lords, the other issue that has been brought out by my learned friends, my lords, the register that my learned friend, Ms. Kilonzo, is talking about is the manual register. Basically, that's what she's referring to now as she was concluding her remarks, not the marked. Now, my lords, the marked register, as we've said, its location is well known. The other register, which is the manual register, my lords, my learned friend referred to the Green Book. You will notice, my lord, that in one of the directions that you gave yesterday, and particular Lady Justice Njoki, she said all registers that were used, because it is clear and it is from our pleadings that in addition to the principal register, there were other people who were not captured in the principal register by virtue of the reason that they did not have fingerprints or their biometrics could not be taken. And there are people, my lords, whose details appear in the Green Book, and that's why we have said, for purposes of ascertaining the registers or the records that were used during the voting period, all the documents that were used must be made available. And one of those is the Green Book. So, my lords, in my view, and it's my humble submission, part of what my learned friend is asking for, it is possible that it will be the subject of what will be argued in the afternoon. Because you have asked my learned friend to come and argue an aspect of the issue of the register in the afternoon. So an aspect of that, my lord, will be dealt with in the afternoon. Now, the clear issue arising, or the clear position that we've been able to enunciate, is that IEBC is not refusing to produce any document. If the court was to direct that the documents be produced, that would be done. The problem is an issue of timing and logistics. How long would...
Continue, Councillor.
Sorry. I hope, my lords, if I lose my train of thought, you'll understand it's a shock. So, my lords, as I was saying, the issue here is not that IEBC has refused to produce any document. The issue is the logistics and the time that it would take. I've already demonstrated that it is not fair to accuse the IEBC of the resultant delay. If this application had been made at the High Court at the same time as the other petition was filed, this question of production of these documents would have been dealt with then and resolved. So, my lords, the delay in asking for this document is not attributable in any way to the IEBC. It is a question of a party who has sat on its rights and didn't make the application at the appropriate time. Now, my lords, the documents that, if there is an order for first of all, my lord, there was a suggestion that was made by my learned friend that if it is difficult to produce all the documents, then produce a few documents. But my lord, that even to the court is unfair, because how will you select the constituencies in which will be produced before the court? And is it that opening up the possibility of someone then arguing that you only selected constituencies that are favorable to one party or the other? So the fact of being near, that some constituencies are nearer than others, cannot be a factor that the court can take into account in determining which of those sealed ballot boxes will be made available.
Mr. Kamau.
Yes.
I can see, to my mind, the way the whole matter is being discussed now. I can see the importance of this understanding, the court to understand these issues of the registers and where they are located, and all issues of logistics. What do you say to the, because we have to also summarize, time is going. What do you say to the issue that under the law, you did not have to be compelled or notices to be produced for you to bring these documents, the registers, that was the obligation, actually to avail it as soon as the petition was filed?
My lord, the only requirement under the rules of this court is for the production of the Form 36s. That is the only requirement that is there. There is no requirement for the production of any other document that is mentioned in those particular statutes. And what has happened, my lord, is that as the parties have been arguing these cases, several documents have been asked for in the High Court, and we have produced those documents. It is not possible for us, my lord, to for want of a better word, to guess what documents someone would be requiring. It is for them to ask for those documents, and once they are asked for, my lord, then the documents will be made available. Because so far, and I hope, my lord, we've been able to make that point, whatever document has been asked for, we have voluntarily produced it. My lord, there is already, as I wind up, my lord, there's already a process that has commenced. The court has directed that commences, which is the scrutiny. And my lord, I have not had my learned friend drawing a distinction between what the court is what the court is engaged in now, and what she requires those documents for purposes of. Because there is an exercise that the court has already ordered and that is underway. And one of the things that, as I heard the ruling yesterday, it is trying to ascertain is the total number of people who voted. That's one of the issues that it's supposed to ascertain. And that is the question that she kept asking us. She says, how will the court know? That's one of the things that the court is, one of the exercises that the court is engaged in. And that is one of the reasons why my learned friend is saying one of the most crucial issues that will be dealt with in the application that he's making you have directed him to make in the afternoon is the production of the Green Book, so that the registers that were used for purposes of voting will be made available to the court so that it can complete the scrutiny exercise.
But you know that the exercise the court ordered at its own instance is confined to only 122 polling stations. And yet it would appear what Ms. Kilonzo is maybe seeking could be the whole entire country.
My Lords, you'll notice, I think it was order number 2 or 3, one of the things that was said is that the Form 34s, Form 36s, would be scrutinized, and that applies to the whole country. So, my Lord, it was not just limited to those. The 22 constituencies, I think it was retallying of the presidential vote. But the rest of the exercise affects all Form 34s. Yes. And, my Lord, lastly, there was the issue of where the documents are supposed to be kept. My Lord, Regulation 93 is very clear about where those documents, after they've been sealed, they're supposed to be kept. And, my Lord, it says, all documents relating to an election shall be retained in the safe custody by the returning officer. That is what it requires. And that is why we are saying, my Lords, that the returning officers are in possession of all these documents, and the only way it can be produced is in accordance with Regulation 93. I've not heard of anybody arguing about the difficulty they had in making an application under Regulation 93, Sub-Regulation 2. None has been led before the court. So for those reasons, my Lord, it's a humble submission that this request that has been made this late in the day will have the effect of making it difficult to conclude the exercise the court is engaged in within the short timelines that are available. And therefore, my Lord, it is not, we would urge that the court allows the remaining time the parties to concentrate on the core job of arguing the petition and leave the court to make its determination. That's all, my Lords.
Friend, Mr. Philip Nyamodi has already addressed the court on for the IEBC as far as we can. We did try, as I mentioned yesterday, as soon as I came, I have mutated, but just to make this clear, we have tried desperately to provide every document that was required, including going to court. As soon as we went to court, we made everything available. And we are now finding ourselves with our backs against the wall, being asked to bring documents from around the country to produce electronic equipment for forensic audits. These are all new issues that have been brought up as we have come into this court. And there is another issue that we have faced in all of this, is the issue of security of our documents. Every time we went to BOMAS after the instruction, I issued an instruction that everything must be made available. We went to counsel acting for IEBC, went to the BOMAS. When they went to the BOMAS, information was given out, and the next thing is we had a raid on the facility at Kenyatta University, if you recall. It was very much in the news. The students went on a riot. They broke into the facility. It turned out that that facility was, in fact, had been hired by the IEBC as a tallying center. But because of our cooperation, the information got out, and the raid took place, the Sunday night a week ago. So I'm not blaming anyone. I'm not pointing a finger. I'm not saying who's responsible, but we have had to be cautious about where these things are also maintained and retained. I'm much obliged.
Thank you, my Lord Chief Justice. My Lords, mine is to voice certain concerns. The first concern, my Lords, is this, that this notice to produce was filed yesterday, 25th March 2013. It is the first day that this document found its way into the annals of what has been filed in this great battle. The document at the first reading is very innocuous. It does not call into play detailed legal submissions because it is framed in the manner a notice to produce is always framed, meaning that the person issuing the notice requires the original documents to be produced by the addressee, failing which the person issuing the notice retains the right to adduce secondary evidence. That is the first reading of a notice to produce. But under the guise of this notice to produce, very, very fundamental statements from the bar have today been issued. Statements from the bar about discrepancies in several electoral areas, that numbers differ in certain electoral areas, that there are indeed doubts about the registered voters in certain areas, and all these are the kind of matters that should be argued tomorrow. They cannot be argued within the purview of a one-page notice to produce. In addition to that, the notice to produce as worded, my lords, should not have engaged you for now going to the second hour. It is not correct management of time that we are now on the second hour arguing on this notice to produce. A formal application should have been made. It was not made. I go to concern number 2, my lords. We are all aware that there was some court case at the Superior Court at Milimani filed seeking production of numerous materials. And those are the materials that found their way in maybe both petitions or one of the petitions. But this is a matter that was in the public domain, that a petition had been filed in the Superior Court seeking production of several materials. This request was not made at that court case. It wasn't made. It was not made notwithstanding.
When my friend is talking, but I do think that he is in error in respect of a request for registers not having been made. Perhaps we may at a convenient time request for that file to be produced.
My Lord, I'm reinforced in that submission, fortified by 3 lawyers, and let it be also known that my client participated in that case. There wasn't a request for marked register. There wasn't any such request.
Senior Counsel, Mr. Ngati, in fact, we were just having a word here, whispering to each other with my brother, Judge Wanjala. Do you think that the court order and perhaps even the entire court record should be brought to the Supreme Court?
Precisely, because that was the second concern I was coming to. That it was open from the day that whoever perceived he will file a petition, it was open to that person to know the materials he or she will require and move the appropriate judicial forum for that material. Yeah, my good friend says there is also another file. I'll come to it as concern number 3. But now for concern number 2 is this. It was open for this petitioner to move the Superior Court from the day that this petitioner decided that the petitioner will file a petition and seek whatever material, including the material now sought in this innocuous notice to produce. My lords, as against that concern, may I request your notes to read that no such request was ever done until yesterday. And why is that important? It is important because it should be known to the 40 million Kenyans that the marked register is kept in a sealed envelope, and that sealed envelope, per regulation, must be kept inside the ballot box and sealed. So the residency of the marked ballot paper, register is already determined by a regulation. It is not kept at IEBC, it is kept where the regulation says. And I go further, my lords. It has not been suggested before you that that procedure was not followed. It hasn't been suggested. On the contrary, we proceed on the basis that the procedure as set out by the regulations has been followed. Having been so followed, it means that what is being requested is in sealed ballot boxes all over the country. Is this the request, therefore, being made so that one of us may have a request to say, I was denied my day in court because I needed these materials and the court did not provide the materials? Is that the driving motivation of this request? I ask this because of this, my lord. Is it practically possible within the logistics available to the electoral body to be able to get all the ballot boxes, open them up, and get that material and deliver it before you, say, by close of day? Is that practically possible? And that is leads me to the third concern. How does the law operate between such competing interests? As I have been reading and also appearing before you, my lords, I've come across various mark decisions, and the current theme appears to be that, be it for scrutiny or discovery, it must be circumscribed by the practicability of doing so within the certain timelines which are set. A request may be given or not be given because there is the practical aspect of allowing or not allowing that application. And the practical aspect about this request is this. If you impose that duty on the electoral body to do it within today or tomorrow, and the answer is they are not able to do it, I see our worthy opponent being able to say, we were denied the opportunity to argue because those registers were not made available. So at the end of it all, if I could use that phrase, my lords, within the competing interests which are before you, what is most preferable? It is that the petitioner, my lords, had every opportunity to make this request. Petitioner did not make it. It is now too late in the day for them to use it and for them to insist on it without even explaining why there was such great delay before they made this request. Let's look at the number of days it has taken before the request was made. Declaration of results, my lords, was on 9th March. The request is made on 25th March. There is a delay of 14 days. My learned friends who appear to have calculators are saying they are 16 days. Yes, indeed, they are 16 days. It's 6 plus 9, 9, yes. Yeah, they are 16 days. It's actually a delay of 16 days.
Did you say 6 plus 9?
Yeah, to come to 5, 6 plus 9 to come to 5, and then the other one goes to 25. So it's 16 days, 16 plus 9 would go to 25. Thank you, my lord. Why do I go to this? My lords, a delay of 16 days has not been explained as a legal requirement. There's not a single word as to why this request was not made for the last 16 days or whatever period of time. I did once argue in the Court of Appeal that any form of delay, because failure to explain it deprives the court the ability to give a judicial order. It is the duty of a litigant to explain why that litigant did not move to court timeously. And failure to delay disentitles the litigant to any favorable order from that court. My lords, if you allow me, as soon as I go back to chambers, I could make that judgment available to you. The controversy in that case was only 30 days that was not explained. A period of 30 days was not explained, and our Court of Appeal said failure to explain that delay disentitles a party to a favorable adjudication of what was requested. So, my lords, because I see inhibitions and obstacles being placed that certain electoral materials are not before you, I would wish to place those 3 concerns before you, because unless they are dealt with decisively at this stage, they will then become the ground for arguing that the trial should not commence tomorrow. Alas, it is the intention of Attorney my client that the hearing should commence tomorrow. That's all, my lords.
My lords, I have 4 issues upon which I oppose the application. The first one, my lords, is that the notice to produce, which has engaged us for the last 2 hours, is actually exhausted, in the sense that the notice to produce was presented. The respondent, which is the electoral body, has confirmed that if the intention is to rely on a copy, they will have no objection and will not insist on production of an original. That, in our submission, my lord, exhausts the scope, the extent, and the purpose of a notice to produce. The second argument that we have in opposition to this motion, my lords and your ladyship, is that the engagement that we have been for the last 2 hours, my lords, are at your instance. And our understanding is that your invitation was limited to an indicator as to whether there is an opposition to the notice to produce or not. An answer to that question has been made to the effect that there would be no opposition to any desire on the part of the applicant to use a copy. My lords and your ladyship, it is our understanding that it was not your intention to use the notice to produce to serve as a scrutiny. We would be very surprised if that intention was there, my lords. That the notice to and your invitation for our comments was meant to give a window to the applicant to engage in a process of scrutiny. The third point, my lord and my lords and your ladyship, is that this is an adversarial process. Scrutiny requires that a formal application be made and all parties are accorded and afforded an opportunity to respond. My lords and your ladyship, we have not been afforded the proper forum and the proper space to respond to an application for scrutiny, and to allow a party to use a notice to produce to achieve the purpose of scrutiny in an adversarial process, my lords and your ladyship, in our view, would be unfair to the other parties. we pray that all parties must take their role seriously and must discharge their obligations within the law and should not assume that the accommodation that the court may have given them in the course of the notice to produce is an open-ended admission or a window for them to enter into scrutiny. My lords and your ladyship, we also pray that you concern yourself with the purpose of the rules you are enacted and the precedent that will emerge, in the sense that a notice to produce is as good as an application for scrutiny. My lords and your ladyship, we pray that it be concerned as to whether that is your intention and the precedent that would emerge from that kind of an approach. Lastly, my lords and your ladyship, we pray that how practical these requests can be done we also are concerned to you, both in terms of time within which you have taken a decision on this issue, and also the fact that other petitions could arise in the different locations where those registers are situated. And my lords, we pray that you disallow the attempt to use the notice to produce for purposes of scrutiny, and possibly allow the applicant to use copies that they have
Please indicate how much time you require. If you don't, we shall give you the time.
Okay. My lords, I'll only require 10 minutes. No more.
I think in the interest of justice, can you take 6?
No, my lords.
Okay, 7.
I will try to confine myself. Yes, my lords. Yes. My lord, this is what Regulation 86 provides. After the final tallying and announcement of results, the returning officer shall seal up in separate tamper-proof envelopes the counted ballot papers, the validated dispute, and shall put the sealed packets in the used ballot box in the presence of candidates and seal the ballot box. The law requires the IE to keep in the ballot box only the items in Regulation 86. Regulation 73 states, 73(3), after completion of the statement under sub-regulation 2, the presiding officer shall seal in separate tamper-proof envelopes the marked copy register and shall seal the envelope with his seal, and shall, as soon as practicable, deliver the ballot boxes and the tamper-proof sealed envelopes. If the register was kept in any ballot box, the IEBC contravened the law. Can a party plead an illegality as a defense to a constitutional and statutory obligation? My lords, the presidential ballot boxes are not in 291 constituencies. They are kept in the county tallying hall. There are only 47 county tallying halls, and I invite the IEBC to give you a replying affidavit showing the contrary. In fact, the returning officer for the presidential election is one, and he is based in Nairobi. He is a person who should be in the custody, who should have the custody of that marked register. My lord, you've been told that we delayed. The petitioners were dilatory. My lords, the petitioners, through the Africa Center of Governance, filed a petition long before the declaration of the results before the High Court. It is public knowledge, and we will provide the court with a copy of that ruling. The High Court said we have no jurisdiction. Go to the Supreme Court. And this is where we are. Do the respondents want to refer us back to the High Court?
Ms. Kidozo, is there an application before us?
My Lord, can I please finish my submission?
No, you have to answer the question. Is there an application before us? Because now you are told the High Court had no jurisdiction. You go to the Supreme Court. But you have not moved the court.
My Lord, the petition was served on the IEBC on the 18th of February 2013, 9 days ago. The first prayer in our petition concerns the principal register of voters. There are allegations and there's evidence that there was a problem in the compilation, certification, and use of the register of voters. They were put on notice 9 days ago. What did they do? We were served on Friday at 5:20 p.m. with an electronic copy of the register, electronic. And once we realized that the IEBC intended to rely on a register that was not used at the election, is when we filed the notice to produce. There can be no question of delay. The IEBC, as I stated yesterday and I reiterate, throughout this process must remain impartial, must remain neutral, must remain accountable, and must open up the voting method they used for verification by this court. That is a duty of the Supreme Court. My Lord, the IEBC is telling this court that it is impossible to produce these manual registers for purposes of verification of the number of registered voters. My Lord, as we speak before you, this court has ordered the scrutiny on your own motion of the number of registered voters indicated in Form 34 and Form 36. My Lord, it is my humble submission that the prayer in which is precipitated in the petition is not for a tally of the total votes cast. The prayer is that this register does not meet the tests of credibility, the tests of integrity. It does not meet the benchmarks in the Constitution. And my Lord, we will leave it to your discretion to determine whether or not that register should be produced for purposes of verification of the number of registered voters who were entitled to vote in the presidential election on 4th of March 2013. That is all, my Lord.
The proceedings in the High Court that were commenced by the petitioner in petition number 4, Africa, sought one relief and one relief only, to stop the tallying of the presidential election as it was going on. The file, I believe, is available, and if the court so wishes, it can call for it and examine that file.
I think, my Lord, I need to clarify that because I participated. I'm the one that I was counsel for Africa that filed that petition. The relief we sought was to stop the tallying and issues of any declarations pending appropriate scrutiny, including verification of issues related to the register, Form 34 and Form 36. So it's not correct that all we wanted was to just stop the process without basis. Thank you.
Okay, since you can't agree, we'll get the files and peruse them ourselves, because you are in the same court and you don't agree. So, do we have the case numbers?
It is petition number 152 of 2013.
Number?
152.
Oh,
High Court.
Yeah.
152 of 2013.
Okay.
155, 2013.
Okay. Can we now, well, the ruling will be delivered at 3. Which ruling? This one, I mean, directions, really. Yeah.
Probably before, as we go to the element of directions, that
Just clarify this to me.
Yes,
Isn't Mrs. Kilonzo your lead counsel?
she's the counsel on record. I'm a senior, but we have agreed that she will deal with certain matters and I with certain matters, especially when we come to submissions. We are equally representing her.
That's what I was.
I think that is not correct.
So, Ms. Kilonzo,
counsel on record.
Ms. Kilonzo,
She's the counsel on
can
record.
we give him a minute to make the point he's making? And you make sure that as the proceedings go, you tell us if he has to make any intervention so that we give you the permission to do that.
Yes, my lords and my lady,
Ms.
may I address you?
Ms. Andubi, you have a minute.
Thank you very much. Your Lordships, the couple of things I wanted to say will relate to directions that you will give. One is the issue of consolidation, in which case the petition number 3 was consolidated with this, but with the clear understanding that petition number 3 is distinct from the others, especially on account that they only seek one relief. And from the assessment, and indeed from the presentation of their counsel this morning, Mr. Joroge Rigeru, it is clear that if the success of their petition, they would actually be seeking reliefs supporting the respondents rather than the other petitioners. And therefore, considering that the consolidation was made for purpose of convenience, we are asking that they should be permitted, on account of time management, to address the court on matters only related with their petition, rather than being asked to comment on everything, because we are starting to get worried about the time. In any event, we would also like that they be identified, even if they are petitioners, so to speak. Their petition is not really a petition for this court, it's a petition that would have been elsewhere. So if they could be defined as respondents, it would be a better idea. Second, my lord.
We need to understand what you're saying.
What I'm saying is,
you are suggesting that a petitioner becomes a respondent, and how would we do that?
in terms of how they are treated within the context of these proceedings, they should be treated as part of the respondents, because their petition is not a presidential election petition per se.
Are you doubting that, are you suggesting that we admitted something that we shouldn't have admitted?
It is an issue that I would invite the court to reconsider its position in that regard, because giving them the opportunity to take the time that they are taking in the arguments in regard to various issues that are emerging in this court, spending a lot of time on those issues, especially when we know that they are contrary to the interests of the other two petitioners, it is important that the distinction is made. Yes, my lord.
Mr. Ndubi, Councillor Ndubi, I thought you were jumping the gun. The issue of, we are going to go back now, the president of the court will soon go to the issue of time allocation. That rather than you standing up to raise a point. We have not finished with the, in fact, we had adjourned the issue of time allocation.
I see. If I'll be given the opportunity to address it at that point, I'm happy to do so. Thank you.
Yeah, it's okay, Mr. Rigeru, you respond when he makes the point. I was saying we have two issues that we're still supposed to finish. The question of issues, right, that you came up with, and then the time allocation. Those ones have to be completed before we break for lunch. But if I remember correctly, the petitions were consolidated. That was the ruling yesterday.
Yeah.
And that's the position of the court. There were arguments that your application be, your petition be heard as a standalone, and we considered that, but we actually said that the three petitions are consolidated. Yeah. Yes. Okay, let's get to the issue of issues. Ms. Angatia,
My Lord Chief
now.
Justice, when we left this court yesterday, I think all of us were totally exhausted. I tried vainly to call a few of my learned friends, particularly my seniors. I was unable to. Consequently, the position remains as it was yesterday. The broad agreement that we shall have 4, maximum 6 issues for adjudication. But I see that the second respondent, that is Ahmed Isaac, has already filed their draft issues. May I therefore, my Lord, with your permission, make a suggestion that once you release us from this honorable court, we file our respective of what we perceive to be the issues, and then we review them in the afternoon with the clear knowledge that since we have been unable to agree, we just filed our draft issues, and it's for the court and the court alone to then determine what are the issues. Because once we determine what are the issues, the rules of engagement will become even clearer tomorrow. And those who would want to start preparing submissions will do so with a clear understanding of what the issues are. We could do that between maybe now and 1 p.m., assuming that we'll be able to leave the court a little early.
Do you have a draft of the 6 issues or 4 to 6 issues?
Yes,
that
I have.
The broad issues, shall we get those?
Yes, I'll send that.
Yeah.
As soon as I get back to chambers. Actually, they were drafted, they were typed by my learned friend, Mrs. Luce Kambuni, Senior Counsel. We'll be able to do that very quickly.
Okay,
and also circulate it amongst all the lawyers, so that if any lawyer is in agreement with that draft, so be it. Any person who feels that the draft is not acceptable will draw the draft that they perceive to be the correct one.
Okay. I'm sorry, after you giving them lunch, expense, this hasn't happened. So what you're suggesting is everybody does what the second respondent has done. Drafts of the broad issues as you, where the general consensus was emerging. Okay. Yes, every party will file their set, but we still want the consensus that was arrived when you are eating. Yeah. So that's fine. We'll get those at 2 then. Or 2, yeah, okay. The last thing is we want to do this morning is the issue of time. If I recollect clearly, Senior Counsel Abdullahi had said that he had a formula, and I think Senior Counsel Oraro also had a formula. So we need to harmonize the 3 and arrive, at a decision, because we have only 15 hours tomorrow and Thursday. So, Senior Counsel Oraro, what was your formula again?
My formula, my lord, my ladies, is that the petitions have to be looked at in the context of each petition requesting for a relief under Article 140, the two petitions. And therefore, in that context, you have to divide the parties into two. The petitioner and the respondents, and allocate them equal time. Because whether there is one petitioner or two, or one respondent or four, the burden remains the same on the parties.
So in terms of arithmetic, what are you saying, so that we get it clearly?
Yes.
In terms of arithmetic.
In terms of arithmetic is take your available time.
Which is 15 hours.
15 hours.
Yes.
Divide it by, take 1 hour out to deal with the issue of amicus and petition number 3. Because petition number 3 is a single issue petition, and it favors the respondents. And the single issue is whether rejected votes should be taken into account in the tally or it should not. So it should be taken out and given specific allocation of time to deal with it, so that it may remain with the actual petitions.
Okay. So, yeah.
Sorry, Madam.
That 1 hour, you left with 14 hours.
Yes.
And then your proposal is?
The 14 hours be allocated equally between the two parties with the respective burdens. That is the petitioner, petitioners, and the respondents. And within that context, then time can be allocated for the petitioners for their 7 hours, and time be allocated for the respondents for their 7 hours.
Okay.
And in the context of the petitioners, we will require a limited time, say 30 minutes, to give our response after the submissions of the respondents, because it is normally necessary to give a response.
Senior Counsel Abdullahi.
My Lord, as I said yesterday, that formula by my learned friend is not fair to the parties, especially to the respondents. I've talked to him this morning about another formula, which is that it's true. I think as he says, or as I think everybody appreciates, that really the substantive petition is petition number 5. In terms of the prayers it seeks, in terms of the evidence it puts for the court, in terms of even the nature of the pleadings. My Lord, I think that's not a major point of disagreement. The other point which he makes, which is also true, is that petition number 3 is a point of law. Both parties, I think, have put in their submissions, especially the respondents, first and second respondents. And I think our legal issues we raised there speak for itself. We won't talk a lot of time. So my view, petition number 4 is really neither here nor there. Of course, with profound respect to my learned friends who are arguing here, it's more of an appendage to number 5 than a standalone petition. More of an appendage to number 5.
3 or 4?
Yes. It's a progeny of number 5, eh? Number 5, it's a slide.
Number 4 is a project of?
Not project.
Oh,
a progeny, sort of, it is an offshot, really, of number 5, eh?
All right.
So my suggestion is, my Lord, that tomorrow up to lunchtime, we can dispose of number 3 and number 4. From 9 to 1 o'clock, or even to 1:30, 2 o'clock. Let us finish with number 3 and number 4. Then.
So that's what, from 9. You're talking about 3 hours.
Even 4 hours, because we want to save. For example, the respondents want to save time in arguing number 3, so that we can save more time for number 5. Yes. We don't want to spend a lot of our time arguing number 3, or even actually arguing number 4. So if it's possible, let us finish number 3 and number 4 in the morning, or even up to 2, 3, so that we can start later. Tomorrow, number 5. I think, of course, my Lord, the fact that there are many respondents, for example, I don't think, for example, respondent number 1 and 2 should have the same time as respondent number 3 and 4. We are the ones who will prove or disprove the case of the petitioner. The burden of proof really lies on respondent number 1 and number 2, IEPC and the returning officer. So even in allocating time between the respondents, it's only fair that respondent number 1 and number 2 be allocated more time than respondent number 4 and number 5. So, for example, if my learned friend gets 5 hours, assume 5 hours, or 3 hours, we must get at least 2 hours. I mean, there must be no huge disparity in terms of time between the petitioner and respondents number 1, number 2 in petition number 5. But I think everybody really agrees with me that we can dispose of 3 and 4 in a fairly short time, so that we address that substantive issue of petition number 5.
Okay, so
because, my lords, I see an injustice almost being committed by my good friend who I have been sitting next to. It cannot be correct that respondent 1 and 2 require more time than respondent 3 and respondent 4.
Can you respond first and foremost to the point being made that we should deal with 3 and 5?
3 and 4.
3 and 4, yeah?
Actually,
because 3 is actually it raises a point of law.
There, I agree with my two learned friends that if you could allocate, say, 30 minutes and actually time everybody on the 30 minutes, we should be able to finish it. As a matter of fact, whoever has more than 5 minutes to say can do written submissions and highlight. 30 minutes, my lords, in my estimation, is more than adequate for petition number 3.
30 minutes?
30 minutes. Then we are left with petition number 4. It may be fairly dangerous to split 4 and 5, but if we are to split them, petition number 4 does not require more than 3 hours. If we are to split them. But the ideal situation would be to hear them together. That would be the ideal. Hear them together as consolidated petitions. Needless to say, the bulk of the accusations are in petition number 5. So I see petition number 5 in whatever time arrangement is given, but petition number 5, which is the pilot petition, being given more time than petition number 4. Actually, in your order of directions, my lords, you use the word pilot petition, and that is number 5. Because petition number 4 raises one issue on one electoral area, we'll be able to deal with that fairly quickly. Then it comes to the respondent's time. My lords, contrary to my learned friend, who I haven't had the misfortune of disagreeing with the greater part of this year, but today I do, we need as much time as the first and second respondents. We cannot put our fate in their hands and say that...
Counsel.
Yes, my lord.
He has offered to carry the burden of proof. I would have taken advantage.
The stakes, my lords, are too high. We will rather carry our cross and carry it all the way to the final destination. It is our intention, my lords, to answer each and every allegation put forth by both petitioners. And we therefore request, my lord, an equal allocation of time between the first and second, and then the third and the fourth. Actually, the better arrangement would have been slightly more, but we can live with equal amount of time.
I think that petition number 4 and 5 should be heard together because they raise common issues. a very small variation or deviation between them. So we will be able to cover the submissions in one go rather than splitting it up. If we split them up, it will take more time to argue number 4 and then put it aside and start another set of arguments. So we would propose that number 4 and number 5 be treated as one and be argued together. In terms of time allocation, the substantial allegations are being made against the IEBC. We need time to respond to those allegations. And we have various thematic areas to deal with, which will take time. I would submit that the IEBC be given more time than any of the other respondents. Much.
So let's get, we've heard you, Mr. Rebel. We are hearing voices, and let's see whether there is harmony. The first voice we've heard is that petition number 3 really revolves around a legal issue. And there appears to be a consensus emerging that it can be disposed of. Of course, we are hearing them together, but in terms of movement, that it can be disposed of within a shorter time than petitions the former petitions 5 and 4. Is that a correct understanding?
I was trying to catch the chair's eye, the CJ's eye on this. Well, everybody's commenting liberally on our petition, so we might as well hear it from the horse's mouth, and this is the horse. Yes, right from the beginning, we did take the view that a pure point of law is raised. We are happy to canvass that at any time that the court directs, even tomorrow morning. The issue here really is in terms of time. I don't think ours is a lesser petition. It is a petition in its own right, with its own prayers, and I think it needs to be given that recognition. My learned friend to the right here, Mr. Ngatia, proposes 30 minutes. With tremendous respect, I would have great difficulties confining my arguments to 30 minutes. I had been allocated 54 minutes, and I can, with some difficulty, bring myself within those 54 minutes. I will not ask for an extra minute. Tie me down to those 54 minutes. I will do justice to my petition, and then open the ground for everybody else.
Okay. I think we are making headway here. Let us move a step further. Let us, all of us, just almost extempore agree how many hours, whether Mr. Reguero will use 54 minutes or more or a little bit less, but how many hours beginning tomorrow are we ready to use to dispose of that point in petition, former petition number 3? And it's by no means a lesser petition. We're just saying that perhaps since it is on a point of law, it could be disposed of much faster than the others. So why don't we agree that what amount of time, how many hours practically? Yes.
My lord, my lady, on my part, I've already put in a written submission. I would encourage all my brethren and my sister. There is only one, and she is amicus, and she's given an opinion in that particular petition to put in a written submission by tomorrow morning.
then you can do the usual thing. You do allocate each of us 10 minutes to highlight our written submissions. And yes, and we finalize that petition.
I think we are making great headway. So can we then agree that parties will put in their written submissions? Of course, Mr. Regeru, I'm sure I can see it by 1 tomorrow. Even less than earlier than that. Or can we dispose of it by 11? 10, okay.
10:30.
Okay, 10:30.
Yeah, 10:30.
Okay. Is 10:30 acceptable? So it is so ordered. 10:30. Then that leaves us now with the two other petitions plus the respondents in those petitions. And I would think that the best way to go about it is to allocate along the lines Mr. Oraro had suggested earlier. To prevent these, we have been given fewer minutes than the rest. We say the petitioners will have equal time with the respondents. Then the petitioners can agree among themselves on how to use that time and come with a report to the court that this is how we are going to use that time. The same can apply to the respondents. And see that Mr. Ngatia and Mr. Abdullahi are going to break this pact of harmony that has prevailed since the court began sitting. I think you will be able to agree as respondents on how to divide that time, and you file that agreement to the court. Is that a proper way to go about it? So it is so ordered.
So we adjourn to 3 p.m. Thank you.